Hello and good afternoon, everybody. My name is Anthony Ray, and I am going to um, be handling the immigration consultation. I want to thank everyone for being here today. Today is our immigration live stream. I'm Anthony Ray, one of the attorneys here at Ray Law International. Been practicing immigration law for a little over 25 years now, and today is a very interesting day. We have a lot to cover, but as always, today is a day for you with your immigration questions that you may have or immigration challenges. That's what we do every day. We solve those. We help companies and employees overcome the various immigration challenges that are out there, and we hear them multiple times a day. So we have offices right now in Chicago, Michigan, and New Jersey, where we represent clients nationally and internationally. And I guess one of the things to get started, one of the really a chat, that's why we're here. We have about 30 minutes. If there's more questions, we'll go a little bit longer. Or if the topic is interesting, we can't cover everything here, but we will cover as much as we can to kind of give you some idea of what are the new regulations and changes, and also how some of the existing green card works for the multinational executive or managers. We'll talk about that a little later. But let's get started first. The first thing we want to talk about, and most important, and we're going to go over this real briefly, not too much today because it is quite a bit of information. It's the new PIP. Go ahead and put that up on the screen. It's uniting families, and this is for individuals who are here illegally, and they're either married to a U.S. citizen, or if they are stepchildren of U.S. citizens. Um, you know, this is something very new, just came out August 19th, and the administration is putting this out there. So what I want to do is share my screen, just go over some of the basic requirements of what this is and sort of the application process. We're not going to get into all the details. There's still a lot. We do not recommend that people file these on their own. This process or this program is right now introduced in order to give U.S. citizens and stepchildren of U.S. Spouses of U.S. citizens and stepchildren of U.S. citizens the opportunity to, one, get work permits, second, to look if they do qualify for adjustment of status. Those are the two main things. So hold on just a moment. Let me share my screen and we'll jump into that. Again, any questions, you guys go ahead and feel free to ask immigration questions, whatever is on your mind. We'd be more than happy to address those. So I'm going to add this to the screen here. Excellent. Hopefully you're able to see it as well as I am. First and foremost, there's a new form called the form I-131F. We use the I-131 for many years for various categories such as advanced parole and reentry permits. Here, we're using it for the new parole in place process. Excuse me. Again, this is for certain non-citizen spouses and stepchildren of U.S. citizens. So if you have a spouse that's a U.S. citizen or you're a stepchild of a U.S. citizen, you need to listen up. This is for you. I'm going to recommend that you get to an immigration attorney such as ourselves. You're going to see our information on the screen throughout the live stream today. Feel free to give us a call at 888-401-1016, and we'd be more than happy to go over this in detailed with you one-on-one. All right. So all of this is going to be online. There is no paper filing. That's one unique aspect. The USCIS has been for years trying to get us to file things online. Although the system is not very reliable all the time. They're still pushing people towards this. We hope the USCIS will either get funding or use their resources to have a more robust, sound system to process all the cases online. But on this one, only online filing. That's very key. Now, if you're represented by an attorney, there is a way for you to submit the form, pay the filing fee, and then also have an attorney represent you. So they have provided that avenue, but it's all through the My USCIS site. If you don't have an account, you can set it up. It's real easy. And if you want attorneys to represent and handle this matter for you, we're able to do that. Again, the filing fee is $580. Not cheap, but the fees that are collected pay for the service provided. So that's one interesting thing. It also includes the background check. Now, as many of you may, or maybe you don't know, the USCIS has all our biometrics. And if your biometrics were recently taken, say, within the past 15 months, then the USCIS may elect to forego the biometrics, meaning they already have your fingerprints, and there's no need for you to come into a local USCIS ASC or appointment service center location in order to have them retaken. So wait for the USCIS after you file to see whether you need to have your biometrics taken again or whether the biometrics they already have on file are sufficient. All right, that's very interesting and very important. Please note also that there may be an interview process, but in most cases, we're not looking for an interview process for the PIP, the I-131F. The US, this is a discretionary. You do not have a right to this benefit. And because of that, the USCIS could deny it outright. They could, without issuing what they normally call a request for evidence or RFE or notice of intent to deny. So people remember, this is something created by the administration. It is not, a right. So make sure you do everything right and have the representation that you need. Another question many people will have is, can we file two at the same time? If one gets denied or it's still pending, can we refile? You cannot have concurrent I-131Fs pending at the same time. That's one benefit of having the online process. They can monitor to see if you have more than one application pending at the same time. All right. So a few more things that we want to go through. Eligibility. Who's eligible? Spouses of U.S. citizens must be present in the United States without admission or parole. Key words. If you were admitted, and overstayed your status, okay, you would not qualify. Or if you were paroled in, let's say you came in illegally, but then you got advanced parole, you came back and were paroled in, you will not qualify for this. That's what's stated here. You have to be married to a U.S. citizen. At least 10 years. You must be continuously present in the U.S. at least 10 years prior. And this is for spouses, not stepchildren. So prior to June 17th, 2024, that's the cutoff date they used. And I like to remind people, a lot of people choose not to get married. We visit a lot of people. It's like, it's just a piece of paper. Here is a situation where, getting married is very important. It's going to allow you to get the immigration benefit. It allows the government to sort of draw a line and make a difference or separate those who are and are not and limit the people who are getting this benefit. So in this case, if you were not married before June 17, 2024, and you then later get married to a U.S. citizen, that doesn't count, okay? So for the we must have interviewed thousands of people in the past few years where, they're just living together, they don't get married, and they're okay with that. And that's fine. The problem is you won't get this benefit. So keep that in mind as you kind of consider marriage in the way that immigration looks at granting benefits to those individuals. So Also, for those out there that say, I just don't want to get married because of the green card, stop that, thinking, get married in good faith. Do it for love. I mean, if you've been with the person for 5, 10 years, you know, there's not much of an excuse for not getting married and then, taking advantage of this benefit. I mean, this could save you a lot of time, money, and heartache. And also, we don't know what's going to happen after November. Everything could change, which is another thing. This is provided right now. If you think you qualify, call today. Don't wait. Lawsuits can stop this process. We haven't seen that yet, but it only takes a month or two for people to get going to object to this. Also, with the November elections coming up, the new administration, whichever it is, may choose to just do away with this program. We don't know. So if you think you have an opportunity and you're married to a U.S. citizen, or you're a stepchild of a U.S. citizen, get there quickly and reach out to us. Our numbers on the screen: 888-401-1016. um, I'm going to just jump. One last thing, we're going to go to stepchildren. Key things here is the stepchildren are not subject to that 10-year physical presence requirement, which is great. And also that is not applied to the U.S. citizen as well. So it's really good for if you have a young stepchild and you're married, you can grant, or that stepchild could get a benefit from that. So call us up. I mean, the marriage must have taken place. Again, it requires that you be legally married. There are a few exceptions, but for the most part, you must be legally married before the child turns 18, okay? And that has to happen before June 17, 2024. You can't run out and get it now. You had to have done it prior to that date. This is why it's so important, even if the immigration benefit will take years, 15, 20, 25 years, you need to file that I-130 or that immigration benefit or get married, because these opportunities just pop up, infrequently and out of nowhere. Okay. So there's a lot more we can go into, if you have a criminal history, what crimes make you ineligible, or, is domestic violence something that's going to keep you from getting this immigration benefit? Mostly, as most people know, crimes such as felonies will definitely keep you from getting the immigration benefit. And another thing that's really critical about this process is, just once you get PIP, you have two options. Once that's approved, then you can apply for your work permit, which is what a lot of people really want. There's a category for that. You have to wait until your PIP is approved, though. You can't file it at the same time. You can file your I-130 at the same time, but not your work permit. And then secondly, everyone wants to know, hey, can I adjust status? Is there a waiting period? Right now, it's no, you don't have to wait. So if you get PIP approved, you can go ahead to the I-485 adjustment of status and start the green card process. Now, you still have to meet the requirements. You still have to be eligible, but there's a lot that you can do. So each case is unique. Reach out to us and let us know if you think you qualify. We'll be more than happy to um, assist you and see and make sure that you qualify or not. All right. So that's the first thing. Our next thing, we want to go over a few updates, and we're going to throw this on the screen. The first one is, what are some of the issues that we're facing in immigration? People ask, well, immigration is just filling out forms and it's real easy. I can do it myself. I don't need an immigration attorney. Here's a couple or a few examples, about 6, where you're really going to need the immigration attorney to support you. First, ICE, we're having an issue with Immigration and Customs Enforcement not seeking the expedite request. There's certain cases where ICE should be expediting the cases and they're not. The next one is their initial refusal or delay in seeking the expedite. The government is not functioning proper in this case. So what we're looking for, us, the immigration attorneys and the Immigration Lawyers American Immigration Lawyers Association, what we're looking for is examples of these. The ALA really wants people to send this information in to see if we can get the USCIS, or excuse me, the Department of State, ICE specifically, to make change and get these things taken care of because we're seeing problems. The next one is ICE did not facilitate the capture of a detained VAWA UT applicant's biometrics. They're supposed to do our biometrics just like we were talking about the PIP, parole in place, in our earlier discussion. They're not doing that. And this is causing problems in moving cases quickly or to expedite the case where the case is urgent or needs to be expedited. The next one is people are being removed and sent out of the country while these applications, the VAWA, the UNT visas, are pending. If you're not familiar, VAWA is Violence Against Women's Act. So whether you're a man or a lady or a child, if you're a victim of violence by a U.S. citizen, then you may qualify for VAWA, or if you may qualify for a U visa if the person's a non-citizen, but you're a victim of a certain crime, or a T visa where you're assisting you're a key witness or assisting them in the prosecution of a criminal that is of interest to the police, maybe the FBI or federal enforcement agencies, then you can apply for these. The government, ICE, is deporting these people while these cases are pending. This is not right. And so we're looking for cases where the ICE is not doing their job or doing things incorrectly. And then finally, something positive that happened this month is H-1Bs, regarding H-1B caps. Each year, the USCIS issues about 85,000 H-1B cap cases, new fresh cases each year. Okay, 65,000 regular H-1Bs and 20,000 advanced degrees. They do their lottery in March. They don't have enough people, so they did a second round in August. So if you were not selected in the first round, make sure your attorney or your employer checks to see if you were selected in the second round. Very important. You only have a short window, so you want to make sure that you find out, get all your paperwork in, and get that H-1B filed ASAP with the USCIS and get to work under H-1B category. It's a prized, category where, for the 85,000, we've got, several 100,000 people applying for that visa category. So make sure you check. Don't give up on the H-1B Don't give up on the H-1B system. Remember, sometimes they even need more, and often we'll see even a third round being taken in October if they don't have enough qualified H-1Bs that are approved. Okay? All right. The next what we're going to move to is our main topic for today. Let me see. I want to see if we have any questions. Again, if you have any questions, now's the time. We're here to answer your questions, not just give out information. Also, for those who speak Japanese, we do have Japanese individuals in the background waiting for your questions. So you can type it in Japanese and we'll get a response to you either now or a little bit later. We can post it on a YouTube or LinkedIn and Facebook so that we can get a response to you. Or feel free, you can call in and speak with a Japanese person as well, speak in Japanese as well. So feel free to do that. 日本語でも大丈夫です。いつでも、チャットでも、電話でもお願いします。And so let's move to our main topic today. And as you saw in our header, we're talking about executives. And we're going to talk about the EB1C, certain multinational managers or executives. Now, this is a wonderful category for those who qualify. A few things that you have to be mindful of in this category. First of all, you must have been employed outside the U.S. for at least 1 year in the past 3 years preceding the petition. And if you are already working in the or you could also be working in the United States right now. You don't have to be outside, but you need at least 1 year within the past 3 years. Um, both companies, both abroad and in the US, have to be doing business. Remember, this is multinational, which means the company has to be in 3 nations, okay? Not just two, for example, Germany and the US. It has to be, for example, Germany, France, and the US, multi-nations. So if the company has offices or businesses in multi-nations or countries, then this is a category. More importantly, you have to be an executive or manager. You have to show that before you came over, you were an executive or manager for at least 1 year within the past 3 years prior to coming into the US. And then you have to be coming to the US to fulfill or be in the position of a manager or executive. Now, manager and executive has their own special definition in the US CIS regulations. So, regardless of what your company thinks is a manager, speak to us because it's totally different. It's a broader definition. You may not have the definition of a manager, but your occupation, your position may be managerial. In this case, what's going to happen? We're going to go over steps real quick. So we're going to go into three steps that you have to look at. So the first is going to be the immigrant petition for alien workers, Form I-140. So the first thing we're going to do is we're going to send out questionnaires and we're going to prepare the petition and obtain supporting documents from you. The petition could include the immigrant petition for alien workers, I-140. As well, it may also include the premium processing if you would like that. Okay, we'll talk about premium processing in a second. Supporting documents, everything that we just touched on. We have to show the company's relationships both here and abroad. Oftentimes that takes a little more work for smaller companies, medium to small companies, because they may not have a public released information in their annual reports that demonstrates all their subsidiaries and how they're related. So we may need to we may need to collect those documents, but also some of those documents may not be in English. So translations also adds into that time. And then also, very importantly, we have to document the position abroad and then here in the US, and that the person actually qualifies for that position. Now, in this process, you do need this employer support. The next thing is there's two main purposes of the petition. The is to assess the employer's ability to pay the wage. Are they in business? The nice thing is we don't have a prevailing wage. We don't have a set wage. But obviously, if it's a low wage, they're getting paid, let's say for this type of position, 30,000 is a low wage, then it may call into question, whether they have the ability or whether this is really an executive or managerial position. Okay, so there's a lot more details to that. That's just an example. The second thing is we want to make sure that the beneficiary qualifies for it. The beneficiary, qualifies as a manager or executive. If I just graduated from college with no experience and I'm put into an executive role for 1 year abroad in the UK and then I come here, they're going to question my ability to be able to perform and run a company, multinational company, in that position with very little to no experience. Next is we filed the petition with the USCIS. A lot of people remember the USCIS is formerly the INS. After 9/11, they changed all that, so now we're dealing with the CIS or USCIS. Regular processing times, everyone wants to know how long is it going to take. Checked it this morning. The current processing times is about 10 to 12 months. Now, premium processing can be used if you want to give the government an additional $2,805. That's going to bring the processing times down to 30 to 45 days. Now, the nice thing about premium processing is even if there's a request for evidence, you're able to communicate directly with a live person and, We don't deal with it much, but in the case there was a denial or some other issue, you can directly contact the premium processing service, okay? And they're going to respond. They're very responsive. I would say for the USCIS, the premium processing um, apparatus and process is excellent. Um, we recently had to communicate with an approval notice we had on a separate matter that's about 6 months old. We emailed them. They corrected the issue just in a couple days. So premium processing, yes, it's awfully expensive, but you're really getting VIP, really good treatment in order for your case. Even after it's approved, they're going to really look at that. So you're really getting your money's worth when you do invest in your case by utilizing premium processing. Premium processing is not for every case. However, there are many benefits to paying that extra money. And then finally, once we filed the case, obviously, we're going to get the approval for you. You know, we don't file cases just to see if they're going to stick. We don't like to take risk risk our clients' money or our time. It's very valuable. So once we get that I-140 approval, then we can move to the next stage. Now, one of the main things is the priority date. Once you have your case filed, it's gonna establish that priority date, and that's gonna allow us and tell us when can we file the green card or adjustment of status if you're in the U.S. or abroad, an immigrant visa. Let's go to priority date and move along. Again, if you have questions, I know we're almost at the 30-minute mark. We probably have, I don't know, maybe about 5-10 minutes left. Go ahead and put your question or drop your question in the chat box, or feel free to give us a call. We're standing by to help you out and support you. Next, priority dates. The priority date in this type of case is established when you file the immigrant petition with the USCIS. Okay. Now, when you file on your receipt notice, they're going to give you a date, and that's going to say when you are in line. Now, we're not going to look at the visa bulletin today, but that's going to help and tell us whether we can file the I-140 by itself or whether we can file the I-140 with the application to adjust status, which is the green card application. Sometimes there are pros and cons to filing them together. Sometimes there are, pros and cons for keeping them, separate. One example is maybe you have an I-140 and your case may not be as strong, and we don't want to waste all the money and time we put into the green card application if we do not have all the information or documents and the client still wants us to proceed. We usually try to steer them not to. However, some people want to move, plow forward in spite of not always following their attorney's advice. The waiting period, as I mentioned, the visa bulletin is there. The visa bulletin, let's go to priority date. Let's see. We're down a couple slides. Let me get us to where we need to be. Just a moment, folks, as I pull this down. Priority date. All right, here we go. So the waiting period, we're going to look at that visa bulletin. It comes out monthly. Right now, the visa bulletin for September is already out. So we can always watch those visa numbers move. Another thing I like to tell my clients is the U.S. government's fiscal year is from October 1st to September 30th. Therefore, that visa bulletin, new fresh numbers come out in October. So always don't give up hope in August and September. They're trying to use up all the numbers, or they may have ran out of visa numbers. So those wait times, sometimes it'll retrogress quite a bit. However, from October and November, you're going to see those numbers kind of revert back or even be progressive and move forward. So don't give up hope during this time of year. That's really what's happening. We're changing the government fiscal year, and we're getting a whole fresh new set of immigrant visas or green cards to dish out to those who are in the process. But remember, you have to file in order to get it. So file those I-130s and I-140s. Next, depending on the visa category in the country, nationality, the wait times vary. For the majority of people, it's going to be reasonable. Some are going to be current. You'll see a little C in that visa bulletin. That's going to mean that you can file both the I-140 and the adjustment of status together. Others, you're going to have to wait a year or two. That's just the way it is. For those from other countries or specified countries such as the Philippines, Mexico, China, and one other, India, there's delays. There's just so many people applying from those countries that there's just not enough visas to go around to everybody. So you're going to see a lot longer delays in those visa categories. So check with us. We'll give you the update. We'll look at the visa bulletin and let you know. All right. Any questions out there? We're moving to the last section, nearing the end. I want to thank you guys for joining us today. Really appreciate it. If this has been helpful, let us know in the chat, okay? If there's a question that we're not talking about, I know we're talking about EB1C, multinational executives or managers, but if there's a separate immigration question that you have, throw it in the chat. Let us know. We're here to help you guys. Or feel free to check us out on our website and email us, or check us out on YouTube. We've got over 400 YouTube videos that are going to help you, keep you informed, and keep you updated. There's a ton of wonderful information coming out through YouTube, LinkedIn, and Facebook almost every day. All right, adjustment of status. Let's move to the next and final leg of our green card journey. The application for adjustment of status or green card application is filed on Form I-485. All right, always make sure you have the latest version. Let's move to the first step. We're going to prepare that application. We're going to get another questionnaire. We're going to collect more information. You're going to get your medical exams done and get all your supporting documents to make sure that you qualify for the green card, okay? Next, we're going to, again, file this with the USCIS. Processing times varies. Right now, the regular processing time is anywhere from 18 to 21 months. That was checked on this morning when you look at the USCIS website for I think it was, I want to say the Vermont Service Center. Not for the 485, for the California Service Center. Why do we choose the California Service Center? Is because that's the largest service center, and that's where the bulk of the cases go. If you end up in a different service center or your case is transferred to another service center, then those processing times will apply, such as Texas, Nebraska, or Vermont. The green card is going to be approved because you hired us, and we're going to make sure everything is done right. Once you receive your green card, it's going to be valid, in this case, for 10 years, okay? No conditional green card here. A 10-year green card, you are done. You have a green card, you are free to travel, you're free to work, or you can feel free to do neither of those. You can just sit at home and watch us on the 90 Day Fiancé. Check us out there as well. We were one of the attorneys they selected, and that was aired back in March. So feel free to check us out on the 90 Day Fiancé. Then after that, one of the key things I like to remind people is because you're a green card holder, or even if you're not, if you're a non-U.S. citizen, the rule is required that you change your address when you move. So if you move down the street next door, you change your apartment, you need to update your address with the USCIS. If you have a pending case, you can also get that updated. You can do that online, submitting your AR-11. It's not very complicated. Some people want help, but make sure it's done in that not only it's submitted, but that you download a copy and keep it for your records. There are so many times where I ask people about their case and they don't have copies, they don't have documents. You're in an immigration case. This is your life. This is your future. This is your family. Organization and tracking your documents is key. At our office, we scan everything in and we make it available to you so that you have it. That's yet another benefit of having an immigration attorney like us handle it, because we're going to make sure, one, that everything is done properly, keep you informed of any changes such as these that we talked about today, and then also make sure that you have a copy, everything's backed up. And if you need your tax returns from 20 years ago and you filed with us, we're going to have it. So that's our topic today. How How was it? Any questions? Was this helpful? Let us know in the chat. Is there something new that you learned about today? If so, let me know. Is there something that you want to learn or hear about next time? Maybe in one of our newsletters that we send out monthly, or possibly at our next live stream. So email us, text us, reach out to us. Let us know what is important to you. What kind of immigration challenges are you facing now? We want to hear from you. Anthony Ray here at Ray Law International. I want to thank you guys for listening in. And if you're watching this after the live stream, write comments in the chat. Let us know what your questions are. We're here. Just to let you know, our next live stream coming up right there on the screen is September 18th. There will be a couple other events that we're going to be speaking at, as I'll be speaking at, which we'll let you know as they move forward. I believe it's in October. So feel free to reach out to us. We're here for you. Thank you so much for listening in today and watching. Until next time, stay on the right immigration path. And thank you. Bye for now.